Judgment in the appeal of the Queen on the application of ClientEarth against the Secretary of State for the Environment, Food and Rural Affairs.
Lord Carnworth will give the judgment to the court.
The European Air Quality Directive sets limits for various pollutants in the air, including nitrogen dioxide. The deadline set for compliance was the 1st of January 2010, and Article 13 imposed an absolute obligation on member states to ensure that the limits and margins of tolerance were not exceeded after that deadline. But there was a possible let-out. Article 22 provided the possibility of applying for postponement for a maximum of 5 years on condition that air quality plans were submitted for approval by the Commission, giving detailed information as to how conformity would be achieved within that extended period. The following Article 23 provides generally for the submission of air quality plans for approval by the Commission, and provides that where the limits have been exceeded and the deadline for compliance has already passed, the air quality plan shall, quotes, set out appropriate measures so that the exceedance period can be kept as short as possible, close quotes. Now, the main issue in this appeal has been the relationship between those two provisions. In the United Kingdom, by the 2010 deadline, the limits for nitrogen dioxide were in fact exceeded in 40 of the 43 relevant zones. Applications for extension were submitted by the Department under Article 22 for those zones where it was thought that conformity could be achieved by the 5-year limit of the 1st of January 2015. However, for 16 areas, including Greater London, for which the Secretary of State did not think that conformity could realistically be achieved by that date, no application was made for an extension under Article 22. Instead, the Secretary of State submitted air quality plans under Article 23, designed to demonstrate that the exceeding periods would be kept as short as possible, albeit after the 2015 date. ClientEarth applied for judicial review, arguing that Article 22 is mandatory and seeking orders to enforce it. The Secretary of State accepts that there has been a breach of Article 13 of the directive, but argues that a declaration to that effect would serve no purpose, and further that an application under Article 22 is not required where conformity is not thought realistically achievable. The Secretary of State succeeded in the lower courts. In this court, the judgment has been given by myself. The Supreme Court allows the appeal to the limited extent that it grants a declaration that there has been a breach of Article 13 of the directive. However, on the other issues, we have decided to stay the proceedings pending a reference to the European Court of Justice, so that it can give guidance on the proper interpretation of Articles 22 and 23 of the directive, and as to the approach which should be adopted by the national courts to their enforcement. Our judgment sets out proposed questions for consideration by the parties and invites submissions on them.
The court will now adjourn.